Good morning, everyone. Go ahead and start your video. Please remain on mute.
Oh,
Go ahead and start your video. Please remain on mute. All right, I'm going to go ahead and roll today's calendar while we wait on the judge to make her announcements. Thank you all for your patience.
All right, good morning, everyone. I'm Judge Andrews. Today is October 22nd, 2025. This is one of the dispossessory calendars for the DeKalb County Magistrate Court. First, I want to thank everyone for your patience as we got you checked in. I also want to thank you for participating in today's hearing remotely. Now, while we are not physically in the courthouse, this is our courtroom and normal rules of court to apply. So court is open to the public. To make sure we are complying with that law, we are streaming this calendar live on the court's YouTube channel. Now, this recording will be removed from the site at the end of the calendar. However, because we are streaming live, I just ask that we not speak out loud people's phone numbers and email addresses, but we'll communicate those as necessary through the chat function of Zoom. Now, other than the court, no one has authority to record these proceedings without giving prior notice and receiving prior approval from the court. And no request to record, so no one should be recording. If you are recording, you do need to stop at this time. Just ask when you're not speaking that you make sure you're on mute. You'll know you're on mute because you'll have a red microphone with a red line through it by your name on your screen. Now, because we're all attending this hearing on Zoom, we are all susceptible to losing our internet connection. So if that does happen to you, just try and reconnect, try a few times. Maybe log off and log back in. If that still doesn't work for you, then please contact the clerk at the phone number you saw in the waiting room. That number is also going to come up here in the chat on Zoom. It is important to contact us if your device fails. If you don't, I will assume you left court before your hearing was concluded, and I will enter an order in your absence. Now, you will know your hearing is concluded when you and I have spoken one last time, and I've told you that you are free to log off of Zoom. Until that point, please make no assumptions regarding the conclusion of your hearing. Now, it should go without saying, but you should not be driving during these proceedings. It can be illegal and also quite dangerous. I do understand, however, that sometimes sitting in your vehicle is the best place to handle court, so it is acceptable to be in your vehicle so long as that vehicle is stationary. Additionally, when I'm handling your case, I just ask that you stay seated or standing in one location. Now, this case is on this specific calendar because the landlord has filed a dispossessory warrant seeking possession of his or her property, and usually also for unpaid rent and other fees that are allowed under the lease, and the tenant in these cases has filed an answer with the court. Now, this calendar does have cases in which the landlord is represented by an attorney and the tenants are pro se or self-represented litigants. Therefore, I'm going to speak with you, the tenants, and give you some basic information about landlord-tenant proceedings here in DeKalb County, Georgia. So essentially, I describe the eviction process as a three-step process. The first step is the hearing we're having today. The primary issues today are whether the landlord may apply for a writ of possession, whether the landlord's entitled to a monetary judgment. Now, a writ of possession does give a landlord the ability to evict someone from property. So if after today the court finds that the landlord is entitled to a writ of possession, they move into step 2 of that three-step process. In step 2, what occurs is the landlord will file a document with the clerk of court called an application for writ of possession. Once this application is filed, it is reviewed by a judge. If appropriate, it is signed. Once it's signed, you move into the third step. In step 3, what occurs is the landlord will call the DeKalb County Marshals and schedule the actual eviction to occur. So it's important to understand it. It's not until these 3 steps have taken place that someone is physically evicted from property here in DeKalb County. Also remember, we are in step 1 of that 3-step process. So today what will happen, in all cases in which both parties have appeared, you will have a private conference or meeting to see if you can come to an agreement to settle your case. Now, you are not required to settle your case, but you are required to make a good faith effort to do so. Now, these are private meetings. They will occur in breakout rooms here on the Zoom platform. Now, the court does not and cannot participate in these meetings, and the meetings are not open to the public. So after I've called the calendar to see who's present in court, you will receive an invitation to your breakout room. When you see that invitation on your screen, please accept the invitation. It will take you directly into your breakout room. It's important then that you remain in your breakout room until the other party comes to speak with you. There are many more tenants here than attorneys for the landlords, so it is important for you to remain there until the other party comes to speak with you. You probably won't be the first person that the landlord's attorney comes to speak with, but they will come to speak with you. And if you move in and out of the breakout room, that really does slow down the process, so it is important to remain there. Now, once you've finished your conversation with the other party, you'll come back here to this main platform where I am located. To do that, you'll find the button on your screen that says either rejoin meeting or leave breakout room. When you come back here, what happens is the attorney, after speaking about 3 to 5 individuals, will also come back out here to this main platform and will report to me on those 3 to 5 cases. They'll let me know if hearings are needed or if agreements have been reached. If agreements have been reached, they'll give me the terms of those agreements. I'll then excuse the attorney to go back to another breakout room. I'll then turn to you, the tenants. I will swear you in, and under oath, I will go over with you the terms of the agreement to make sure you do in fact agree to those terms. If you do, I make it the order of the court. And then what happens is after today, the attorney sends me a proposed written order with those terms. If it is all accurate, I will sign it, send it to the clerk, and the clerk emails you a copy. So you do have some written documentation of what happened in court today. Now, if you're unable to reach a resolution today, we'll set your case for a hearing. Generally, those cases are reset to a later date in person at the DeKalb County Courthouse. One of the requirements of the law is that if your case is reset from today's date, that you pay rent into the court registry. That's any past due rent and any rent moving forward. Now, if you're one of those individuals whose case will be reset to a later date, I will speak with you in more detail about that, let you know when your next court date is and what to expect. I'll then reduce all that information to writing, put it in order, sign it, send it to the clerk. The clerk will email you a copy, so you also have some written documentation of what occurred in court today. Now, before you go into your conversations with the other party, it's important to understand a few things about landlord-tenant law here in DeKalb County, Georgia, or here in Georgia in general. And one of the things to understand is that here in Georgia, not having money to pay rent is not considered a legal defense. Now, it very well could be a legitimate reason why someone's unable to pay rent. Often people will lose jobs, become ill, unforeseen circumstances do arise in people's lives that make it difficult to pay rent. So while it very well can be a legitimate reason why someone does not have the financial ability to pay rent, do understand that under Georgia law, it's not considered a legal reason or a legal defense. So if the sole reason you did not pay rent is because you did not have the financial ability to do so, do understand that those are cases in which the landlord would be entitled to a writ of possession. Now, in all cases in which you have a hearing before the court and the court finds that the landlord is entitled to a writ of possession, I, as the judge, can only give you the tenant 7 days before you must vacate the property. Said another way, 7 days before the landlord can move into step 2 of that 3-step process and apply for that writ of possession. Do understand that the law gives me absolutely no discretion in this matter. There is no hardship exception. So if you are to have a hearing, I am limited to those 7 days. Now, if you do enter into a consent agreement with the parties can agree to any date that that writ can be applied for. Consent agreements, you generally have a lot more flexibility to do what works for both parties. That's not the same case if you have a hearing. If you have a hearing before me, I do have to follow certain rules of law, and one of those is that 7-day rule that I explained to you previously. So just kind of be aware of that when you're deciding how you would like to move forward with your case. All right. What I am going to do now, as I said, I'm going to call the calendar to see who's present. When you hear your name, please unmute. You should all have your cameras already on, so it will be easy to unmute and audibly let me know you're here with us. Once I finish calling the calendar, you will receive invitations to your breakout rooms. As I said, please do accept those invitations, and an attorney will be there to speak with you. All right, position 1 on the calendar, 25D 17761, 2929 Atlanta Holdings, Villas at Panthersville versus Jareen Fort.
Here for plaintiff, Your Honor. Good morning.
Good morning. I don't see Miss Ford. I think this is, there was already a consent agreement. I believe I might just be signing the writ today. But I'll
Okay,
verify that.
that would be great. Thank you.
I think it might have come on the calendar in error. That might have been my mistake. Position 2, 25D 21809, Commons at Briarwood Holdings, number 1, the Commons at Briarwood Park versus Camille Jones.
I'm in that case, Judge. We're here on defendant's motions.
Yes.
And I'm ready for all the other Mike Williams cases.
Okay, thank you.
Okay.
And is Mr. Jones present?
I see him here.
I'm not seeing him. Mr. Jones, if you can unmute and let us know you're present. I'm just not seeing you.
Yes. On behalf
There
of
you
the
are. I see
principal,
you. Okay. Position 3 on the calendar, 25D 22216. Lakes at Indian Creek property owner, Village at the Creek versus Nikiria Davis. And apologies if I mispronounce people's names.
Ready for plaintiff?
Looks like no response then. Position 4, 25D 22498, SMP Lakeview SPE Ascento Real Estate Partners versus Jasmine Davis.
That's me.
Thank you. All right, position 5, 25D 23514, AVPD LLC Sterling Villas versus Kelsey Reese.
Ready for plaintiff?
No response. Position 6, 25D 23786, Spyglass Decatur East, Portland Decatur versus Shaquila Graham. I see Miss Graham. Miss Graham, just give me a wave. Do I know you hear me? There you go. All right, Miss Graham's here. Position 7, 25D 24322, Ken Edwards Enterprises, Hampton Hall Apartments versus Christopher Williams.
I'm here, Your
Oh,
Honor.
there's Mr. Williams. Thank you. I see you now. All right, position 8, 25D 24645, BLP Apartments owner, Arium Lennox Park versus Basil Waldron. No response. Position 9, 25D 24726, Brandywine Homes, CPILC SFR Program Venture versus Rochelle Whitlow.
Ready for plaintiff?
It's no response. Position 10, 25D 24852, Elan Property Management Company, Willow Run Apartments versus Dwana Giles. I see a screen name with,
I'm here.
okay, great, thank you. Position 11, 25D 24853, Elan Property Management Company, Willow Run Apartments versus Thomas Rowland. It's no response. Position 12, 25D 24940, Southern Oaks FO, Southern Oaks Alexander Properties Group versus Darcel Jackson.
Ready for plaintiff?
Here, good morning.
Good morning, thank you. Position 13, 25D 24999, Bell Rock Management Affinity at Stone Mountain versus Jasmine Hampton.
Here.
Thank you. Position 14, 25D 25020, Covington Glen Stonemark Management versus Jason Dixon.
I'm here, Your Honor.
Thank you. All right, position 15, 25D, 25125, Covington Glen Stonemark Management versus Shamika Hurd.
I'm here.
Thank you. Position 16, 25D, 25129, Covington Glen Stonemark Management versus Carlos Edwards.
I'm here.
Thank you. Position 17, 25D, 25135, Covington Glen Stonemark Management versus Amani Allen and Genuine Glover. I think there's Miss Allen. I think I see Miss Allen. Give me a wave, Miss Allen. Thank you. And I don't see Glover. That's all right. Position 18, 25D, 25138,
We're
Covington
both
Glen.
here. Sorry.
Oh, you're
I
both
couldn't.
together?
Yeah, I am. I couldn't unmute. I'm sorry.
You're fine.
We're both
All right,
here.
just make sure that Miss Glover's on the screen when you're talking with the attorney, okay?
Okay. Yes.
They can see both of you. All right.
Okay. Thank you.
All right, position 18, 25D, 25138, Covington Glen Stonemark Management versus Jalexis Lee.
Here.
Thank you. Position 19, 25D, 25157, Covington Glen Stonemark Management versus Veronica Figueroa. I see Miss Figueroa. Just give me a wave there, Miss Figueroa. All right, marking you as present. Position 20 was dismissed on October 20th. Position 21, 25D, 25162, Covington Glen Stonemark Management versus Keith Darden. That's never, oh, there you are, Mr. Darden.
I'm here.
Thank
I was
you.
trying to unmute.
Understood. Thank you. Position 22, 25D, 25164, Covington Glen Stonemark Management versus Adrian Outen, Outen.
I'm here.
Thank you. All right, position 23, 25D, 25165, Covington Glen Stonemark Management versus Charlia Henderson and Mia Jenkins.
Here.
Are you both there, or is that just Miss Jenkins?
Just Miss Jenkins.
Okay, thank you. All right, position 24, 25D, 25170, Spaxel Hidden Colony versus Jarvis Williams and Lilani Smith.
Ready for plaintiff?
Is that Mr. Williams?
Yes, ma'am.
Is Lilani Smith with you?
Yes, ma'am.
You're both together on the same screen? Or
I can get
can
it.
be together? Okay.
Yeah.
All right, great. Thank you. All right, position 25, 25D, 25394, AHB SFR Henley Avondale versus Jolly Moody.
I'm here.
Thank you. Position 26, 25D, 25403, Avondale 212, Avondale Station versus Shonda Douglas and LaKeebler Douglas.
I'm present.
And what is
just
your name?
LaKeebler.
And it's just you?
Yes.
Great.
My aunt lives in another state.
Great. All right, got it. Thank you. All right, position 27, 25D, 25420, Vista Boulder Crest versus Kanaya Isham, ISHAM.
Hey, I'm present. Good morning. It's
Good morning.
Aishan.
Aishan? Is it
Aishan. Yes, ma'am.
with an M at the end?
Yes, ma'am.
Okay, got it. Thank you.
Thank you.
All right, position 28, 25D, 25426, Vista Boulder Crest versus Patrice Fagan. Thought I saw her. There she is. Thank you, Ms. Fagan. I see you. All right, position 29, 25D, 25481, 1500 Oak Equities, the Ellis versus Frank Ngimbi. NGIMBI. No response. Position 30, 25D 25484, 1500 Oak Equities, the Ellis versus Makiba Etheridge.
Here.
Thank you. All right, that completes the call of the calendar. You will receive invitations to breakout rooms. Please accept those invitations, and after people are moved into the breakout rooms, I will begin the hearing on position 2. Just give me a moment to pull that up. And that's Commons at Briarwood Holdings versus Kamal Jones.
That's Kamel Jones.
All right, thank you, Kamal Jones then. All right, Mr. Jones, we can start with your emergency motion for temporary restraining order. It's your motion, so I'll hear from you first.
Yes, to forward to the proper court to hear my complaint in full. There's RICO allegations involved, which I understand you don't have the capacity to overhear. As a matter of fact, you stated that the last time, but mysteriously you continued and you didn't transfer it.
All right, so let's go back a little bit in time so I can put on the record exactly what I recall happening when we were in court last time, or when I was here in court last time. Let me take a look at my notes.
I'm sorry, Judge. Why you do that? Position 21 and 18, I need you all to go in the breakout rooms. Lee and Darden, I need you all to join the breakout room. I sent you a prompt.
If I remember correctly, I was here on September 11th at 9 a.m. representing the landlord was Miss Lewis from Mr. Mike Williams' office. When we got to the case, Mr. Jones indicated that he wanted the case transferred. Miss Lewis at that time didn't have an objection. I hadn't really looked very closely at the answer because there was no objection at that time. So I did indicate it would be transferred. Subsequent to that, it appears that the landlord's attorney looked at the case, realized that they actually do have an objection to the transfer. So they appropriately filed a motion indicating that they needed a hearing or requested a hearing and asked that the case not be transferred. Once I received that motion, it was put back on a calendar so that issue could be addressed. That case was then reset for a hearing before Judge Kleinrock on September 22nd, 2025, to address the landlord's objection. It appears that notice was sent to all the parties. The defendant did not appear The landlord did appear. I believe the landlord at that time was represented on that date by Mr. Williams. A default judgment was entered. Also noted, defendant failed to appear after receiving proper and sufficient notice, and defaults defendant's motion to transfer was denied. All right, subsequent to that, I had got a motion on September 23rd, 2025, emergency motion to vacate faulty judgment and strike false order.
I never received any documentation to appear. You stated one thing while I was in front of you, and then once you allowed me to leave the Zoom, you came up with some other. You continued the case without allowing me an opportunity to speak on it.
That's not what happened at all. Once you left the Zoom on September 11th, your hearing was concluded. I no longer discussed your case with Miss Lewis because I would not do that if you were not present. Subsequent to that, as I indicated, the landlord filed a motion, which
Well,
they have the
I
right.
know.
Excuse me, Mr. Jones, I am speaking. The landlord filed a motion as they have the right to do so. Clearly, you know you have the right to file motions. You have filed numerous motions in this case. They filed a motion, and that motion was set for a hearing. You received notice to come to court.
I received the notice after the court date.
So you're telling me you never received notice to come
I
to court?
received the notice after the court date.
What court date specifically?
As a matter of fact, I received the default before I even received the notice to appear.
Okay, so are you talking about the notice for the September 22nd court date? Is that the notice you're referring to?
Yes.
Okay.
I never received that notice to after you said it was in default because I didn't appear, when I was never made aware of it to afterwards.
What is your email address?
It's choice one. I received it.
Mm-hmm.
However, I received the default before I received the notice to appear.
Well, the notice was emailed to you on September 15th and September 19th.
And it was mailed, it looks like, from the docket.
So that's probably why the judge on September 22nd found that there was sufficient and proper notice.
Okay, if you tell me one thing, ma'am, I'm going on what you're telling me. You're
Yes, and I
stating
also
that
told
you're
you,
gonna.
Mr. Jones, I also told you to come back to court on September 22nd.
Okay, well,
and you didn't come back to court.
I never received that information to afterwards.
Well, I find that hard to believe. It was emailed twice
You have to
and
give,
sent to you.
ma'am, it takes approximately 4 or 5 days for mail
send an
to
email?
come to, no, for actual mail to come. I received the mail after I received the default.
And what about the email? You're telling me you never received emails?
You never stated that you was going to send me emails. I don't check my email every day, ma'am.
That's on you.
Oh, so I just supposed to know that you're going to send me an email.
What are you asking this court to do now, Mr. Jones?
Well, I want to transfer the case to the proper venue where I may state all the facts, being cheated out of funds, using illegal software, and a host of other allegations that I have against this company.
Okay, well, this is a dispossessory court. I'm looking at your initial answer. So on September 2nd, 2025. And actually, when I read through that answer, there's nothing in there that mandates a transfer to state court. So that motion is denied.
Okay, well, I spoke with you personally,
I
and you
understand that.
stated that you were going to transfer it. You
I
didn't
did.
have the capacity.
I did, and then there was a motion submitted by the landlord that they objected to that transfer, so we brought it back to discuss that objection. And when they came back and presented their objection, it was clear then that there was nothing that stated that it must be transferred to state court. There was nothing in your answer that stated that.
Okay,
And
do you
they in
have
fact objected it.
the ability to preside over RICO allegations?
Mr. Jones, your request to transfer this case, the landlord-tenant matter, is denied. Now, if you have anything else you want to file in a different court, you're welcome to do that. But in terms of this dispossessory, the transfer of this dispossessory is denied. You are welcome to file whatever you feel is necessary in other courts. That is in regards to the dispossessory. That will remain here in magistrate court.
Well, I'll just file it in federal court.
Anything further then from you, Mr. Williams, on this matter?
No, Judge, we're just asking that his motions be denied in their entirety. You know, he had an opportunity to argue that on the 22nd, as the court pointed out. In addition, you know, he states.
No, I didn't have the opportunity to
Mr.
argue it
Jones,
out.
Mr. Jones, please don't interrupt.
Y'all spoke on the matter after
Mr.
y'all
Jones,
dismissed me. I didn't.
Mr. Jones, please do not interrupt the other party when they're speaking. They did not interrupt you, and I ask that you not interrupt Mr. Williams.
Yes,
Make it
even
proceed.
if you're going to consider the counterclaim that he filed, I mean, it appears to be borderline sovereign citizen stuff. UCCs being asserted and claims like that are not applicable to this court. In addition, he's claiming he's got some secured interest in this property, which is not. You can't claim defects in the landlord's title in a dispossessory action. This clearly was an attempt to try to delay this case, and so we'd ask that the motions be denied in its entirety, and that the order dated September 22nd, 2025 remain the final order of the court.
All right, Mr. Jones, is there anything additional you'd like to put on the record before we conclude this hearing?
Right. Well, of course, I don't agree to that. It's clear that the case was improperly handled. You didn't allow me enough time to receive notice, and I'll have to take it to the proper venue. Federal court has already struck against that because they're aware that you don't have the capacity to overlook this matter.
All right, thank you. Well, Mr. Jones, your motions are denied. The September 22nd, 2025 default judgment will be the final order in this case. And that does conclude the hearing on this matter.
Well, it was already struck down by a federal judge, so I'll just resubmit it back there again.
Do I need to prepare an order, Judge?
I can prepare an order.
Thank you.
That would be fine. All right, that concludes this matter. All parties are excused. Mr. Young, do you have some announcements?
Yes, Your Honor, I sure do. Let's see, starting with position 12.
12, yes.
That's Ms. Jackson, yes. All right. So yeah, so Miss Jackson, she's just planning on turning in keys today.
Okay.
So what we've agreed to is that the writ of possession would go into effect tonight at 11:59 p.m. Of course, if she turns in keys, then that won't be necessary. And then we calculated and agreed to the judgment through today of $27.90 and 87 cents.
Okay. Any further announcements?
Yep, I've got one more.
Okay.
And these are all of my cases of those who are here. Yeah.
Okay.
All right. So position 24 is the other case I have.
Okay.
All right. So yeah, they're planning on just working out payment with the property by the end of the month. So what we've agreed to is the writ of possession October 31st at 11:59 p.m. Judgment through that date of $37.31 and 90 cents.
All right. All right. So I will have the Jarvis Williams, Lalani Smith, excuse me, and on position 12, Darcel Jackson, if you can all unmute and raise your right hands. And Mr. Williams, was there someone else with you, or is it just you?
I would say I can get in here. Do I need it?
Okay.
Lonnie, come here.
And Darcel Jackson, if you cannot turn on your camera. There we go.
Okay, she's
All right.
here.
Okay, perfect. Do you all three swear or affirm the testimony you shall give shall be the truth under penalty of perjury? Ms. Jackson?
Yes.
Mr. Williams?
Yes, ma'am.
And Ms. Smith?
Yes, ma'am.
All right, Ms. Jackson, for position 12, did you agree that a writ would issue after October 22nd at 11:59 p.m.? I do understand that you are planning to turn in the keys, but did you agree to that? Okay. And do you also consent to a monetary judgment in the amount of $2,790.87?
Yes.
Okay. Then I'll make that agreement the order of the court, and you are free to log off, all right?
Thank you.
Thank you. Take care. All right, Mr. Williams and Ms. Smith, did you both agree that a writ would issue after October 31st, 11:59 p.m.?
Can anybody hear me?
Now I can hear you. So Mr. Williams, did you consent that a writ would issue after October 31st, 11:59 p.m.?
Yes, ma'am.
And Ms. Smith, did you consent to the same?
I'm sorry, we're trying to get ready for work. Lonnie, she needs you to agree.
Did you agree that a writ would issue after October 31st, 11:59 p.m.?
Yes.
Okay. And did you both consent to a monetary judgment through that date in the amount of $3,731.90?
Yes.
Yes, ma'am.
All right.
Yes.
That'll be the order of the court. I will let you guys go. It seems you need to get ready for work. So good luck. All right. You both take care.
Thank you.
All right, Mr. Young, then is it all that you have as defaults left?
Yeah, a lot of no-shows.
Okay, one is the writ that I need to sign. Let me do that right now before I forget.
And I do have a client here for that. I think he's back in the waiting room. He was just here in case you need to hear any testimony.
No, I think what happened is I didn't realize that she had already come to court and entered a consent judgment. I thought it was prior to that.
Oh, okay.
We've been concerned with service issues kind of going on. And so I think that just sort of got my wires a little crossed on that one. So let me go ahead and sign it while we are here. Oh, I did sign it.
Oh, okay.
Okay, so it just needs to be, I'll just put a note that it can be processed then.
Okay.
Okay.
Sounds good.
All right, sounds good on that one. And where to next then?
The next one was position 3.
Okay.
So this was one where it was a late answer, and we've already filed for the writ, but then they filed or I guess the court put it on for some reason. So I'm fine with whatever the court wants to do since they're not here. If you want to just keep the late answer as late and sign the writ, I'd be happy with that, or we could do a default.
All right, I will go ahead and let me see. Oh, here it is. I'm going to go ahead and we'll sign the writ on this one
Okay.
then.
Sounds good.
All right. All right. I've signed the writ on that one.
All right. Thank you.
And let's see where to next.
Next, we got position 5. I guess it's the calendar of weird things coming back. This was one where we had already been to court on a hearing and got a default, and then they filed something saying they had issues with joining or something like that, so it was put back on. But I guess they're not here again.
Oh, let's see. Okay. So there's already a proposed order and they're not here again. Is this say there's already, so there's a default order in here. Do you want me to sign that, or is there something different to submit now that it's
No, I'm happy with, if
what's
they're not
there?
here to argue their motion for, to set aside the default, I would just ask the default remain in place.
Okay. Let me get that.
And I don't know if let me double check. Do you see in your system, have we already applied for the writ on that? Maybe we haven't.
Don't.
Which position is this?
That's position 5.
Yes, it's a writ on file.
There is.
Okay.
Okay.
Let me go find it then. There it is. Okay.
Oh, thank you, Ms. Hart.
Let me sign that.
And I think that I had a client here for that case as well. I don't know if she's logged off when she saw they weren't here or if she's in the waiting room.
All right, that writ is signed. Okay. And is number 9 the next one?
Number 9 is the next one. Yep. And this is another one where it was a late answer that got put on the calendar.
Let's see what happened here. And they're not here, so I will sign that writ.
Okay. Signed. And that's it. So no, I guess no true defaults, all just stuff coming back.
It's one of those days.
Yep. Well, that's all I've got. I'll be back for my one case this afternoon.
Oh, okay, we'll do.
All right. See you then.
All
Have a
right.
good lunch.
You too.
Bye.
Mr. Hodges, do you have some announcements?
I do. Number 4 is a consent. Miss Davis and Mr. Xavier Green showed up. Mr. Green was on the answer as well. So this includes both of them. It's a consent. They're going to try and work it out. Writ to issue November 2nd, 11:59 p.m. and a judgment for 41.2233 cents.
Okay.
Six
Okay. Ready?
is a consent. She's going to try and get it worked out. Writ to issue November 2nd, 11:59 p.m. and a judgment for 5,030.04 cents.
Okay.
Number 10.
10. All right.
She's going to try and work it out, but it's a consent. Writ to issue November 2nd, 11:59 p.m. and a judgment for 24.26.96.
Okay.
And then 13, we're going to continue to confirm payment. We will probably have the dismissal in before the end of the day if this goes like
Okay.
they usually do. Yeah.
All right. Anything further?
Nothing right now.
All right. We're gonna. So 13, you are going to confirm payment. Is that what you said?
That's right. If we could maybe put it on, I mean, we can put it on a calendar a week
Yeah.
from today, and we'll have that information
Okay.
by then.
We'll just reset it for 1 week. Well, Ms. Hart, can we reset it for 1 week? And then obviously if it's been dismissed before that,
Okay,
Ms.
thanks.
Yes.
Hampton won't need to be here. So what's the 30th no, sorry, wrong date. The 29th at 9 a.m.
Yes.
Okay. Ms. Hampton, we are going to continue your case to October 29th at 9 a.m. If the landlord dismisses it before that time, then you don't need to appear, okay?
Okay.
All right, but you are free to log off, all right?
All right. Thank you.
Thank you. All right, I'm gonna have the following individuals unmute and turn on your cameras, and we'll go over your agreements. It's going to be position 4, Miss Davis and Mr. Green. Position 6, Miss Graham. Position 10, Dewana Giles. And yes, if those individuals unmute and raise your right hands. Do you all swear or affirm the testimony you shall give shall be the truth under penalty of perjury? Miss Giles?
Yes, ma'am.
Thank you. Miss Graham?
Yes, ma'am.
Thank you. And Miss Davis?
Yes, ma'am.
All right, can all lower your hands? I'm going to go chronologically. That's going to start with position 4. Let's see, Miss Davis, did you agree that a writ would issue after November 2nd, 11:59 p.m.?
Yes, ma'am.
Did you consent to a monetary judgment through that date in the amount of $4,122.33?
Yes, ma'am.
All right, that will be the order of the court. Then you're free to log off. All right.
Thank you.
Thank you. All right, Miss Graham. See, did you agree that a writ would issue after November 2nd, 11:59 p.m.?
Yes, ma'am.
And did you also consent to a monetary judgment through that date in the amount of $5,030.04?
Yes, ma'am.
Okay, then it will become the order for you, and you are free to log off. All right.
Thank you.
Thank you. All right, Miss Giles, position 10. Let me find you. There you are. Did you agree that a writ would issue after November 2nd, 11:59 p.m.?
Yes, ma'am.
And did you consent to a monetary judgment through that date in the amount of $2,426.96?
Yes, ma'am.
All right, then I will make your agreement the order of the court, and you're free to log off. All right, you take care.
Thank you. Have a great day.
You too.
Judge, I have 3 cases that I've resolved.
Okay, I'm ready.
Position 7, Mr. Williams, we are providing for a writ on October 31, 2025 at 11:59 p.m.
Mhm.
Total judgments, $4,465.90 plus costs.
Okay.
Position 18, Ms. Lee, We're providing for a writ on October 31st, 2025 at 11:59 p.m. Judgment for $2,597.86. And the resident's trying to get it worked out with the property.
Okay.
Last one, Moody, same thing. Writ of possession, October 31, 2025. Judgment, $4,400 plus costs. And Miss
Wait,
Moody,
what number was that one?
I'm sorry,
25?
25,
Hold on.
Moody.
Mr.
Sorry.
Moody. Okay.
I'm
All right.
sorry.
That's fine. If you could start that one over for me.
Sure. October 31, 2025 at 11:59 p.m.
Okay.
Judgment's $4,400 plus costs. And the residents trying to get this worked out and get it paid.
Okay. Sounds good. Thank you. All right. I'm going to have the following individuals unmute and turn on your cameras. That's position 25.
Excuse me,
Moody.
Judge. I was kicked from room 23 and was trying to get back in there.
Okay. Miss Hart, can you help Miss Jenkins get back? We'll get you in there, Miss Jenkins. All right. All right. Position 25, Miss Moody.
Okay, thank you.
Position 18, Lee, and 7, Williams. I'll have you all unmute and raise your right hands. Do you swear or affirm the testimony you shall give shall be the truth under penalty of perjury?
Yes.
Yes.
Yes, I do.
All right, heard all three of you. I'm going to start chronologically. Position 7, it's Mr. Williams. Did you agree that a writ would issue after October 31st, 11:59 p.m.?
Yes, ma'am.
And did you consent to a monetary judgment through that date in the amount of $4,465.90?
Yes, ma'am.
All right, we'll make that the order in your case, and so you're free to log off, all right?
Thank you. You have a wonderful morning.
You too, thank you. All right, number 18, Jalexis Lee. Did you agree to a writ would issue after October 31st, 11:59 p.m.?
I thought it was before.
Well, if you're still on the property,
We issued the writ on the 31st. If you get it resolved before then, and they accept money, this case will be over. But if you don't, after the 31st, they could execute the writ.
Okay.
okay, does that clarify that, Ms. Lee?
Yes, ma'am.
Okay, and did you consent to a monetary judgment through that date in the amount of $2,597.86?
Yes, ma'am.
All right, we'll make that the order of the court, and you're free to log off, all right?
Hey, I got a quick question. Am I going to get that in the email saying it was 25?
You're gonna get in an email order, yes, with the amount and the writ, the date of the writ of possession. It will be in
Okay.
an order. It will be emailed to you, okay?
Okay, thank you.
You're welcome. All right, position 25, Moody. See, did you agree that a writ would issue after October 31st, 11:59 p.m.?
I did.
All right, and did you consent to a monetary judgment through that date in the amount of $4,400?
Correct.
Okay, then that will be the order in your case, and you are free to log off. All right, you take care.
Thank you so much.
All right, bye-bye.
And goodbye.
All right, Judge, you should be able to move through the rest of them. I'm wanting to take care of the sticky
All
one.
right. Thank you.
Thanks, Judge.
People in the waiting room.
I let them in. I was trying to see who they were, but they were never responded to me. Probably
Derek
some of the
Powell.
witnesses. Yeah, I didn't see that name on the calendar. If you can hear my voice, please go ahead and start your video. I was trying to communicate when I couldn't. I didn't get anything. I was thinking maybe one of them is a witness.
Yeah.
For Young, but I couldn't get anything.
Person with the screen name Penco Corporate Collection Manager. If you can unmute and turn on your camera. All right. So we can just put them back in the waiting room till they respond. Can check on Derek Powell. Did you try to? I don't see that name on here either.
Yes, I was trying to speak with them as well. I didn't see that name on the calendar. I I clicked on them to join. I guess it's still trying to. It's buffering. Mhm. Oh, well, they left. I'm pretty sure it probably was a witness.
Hello?
Yes, sir. Do you have a question?
No, he was sending me back to the courts to
Okay, that's fine. So we're just waiting here for the attorney to come back to go over the terms of your agreement with the judge. So you can go off camera for now if you would like.
all right, that's fine.
I have a few announcements.
All right, I'm ready.
We stopped at before 14, right?
I'm 14.
14. All right, let's do 14. Ready?
Yes, I'm ready.
All right. He's going to try and get it worked out, but there's a consent writ to issue November 2nd at 11:59 p.m. and a judgment for 3278.41.
Okay.
And then 16.
15?
15, I couldn't get her to answer.
Okay, 16 then, he said?
Yeah.
Okay.
16, they're going to try and get it worked out, but it's a consent writ to issue November 2nd, 11:15. Wait a minute. Are they here? I'm sorry.
Yes, sir.
Yes, he's here.
Okay, making sure. I didn't see. Writ to issue November 2nd, 11:59 p.m. and a judgment for 2542.96.
Okay.
17, Miss Allen is here.
Yes.
Is Mr. Glover here, Miss Allen?
He actually stepped out. We have a 7-month-old, so he's in the other room, but he is here.
All right, okay. So we'll do the judgment with both their names.
Okay.
There's a consent writ to issue October 31st, 11:59 p.m. and a judgment for 2526.91.
Okay.
And then it looks like I have a witness that just showed up. I think they're from number 7, maybe. Kenco Corporate, are you here?
I don't know. We've been trying to get them to respond, but no one's been
Okay.
responding to us.
All right.
So,
Covering a base. All right. I need to step away for a minute.
okay.
Excuse
All
me.
right. I'll have position.
I do apologize.
All right, we'll come back to you in a moment. I can have Mr. Dixon, position 14, 16 Edwards, and 17 Allen. If you can all unmute and turn on your cameras, I'll swear you in and then we can go over your consent agreements.
Yes, ma'am.
Do you all swear or affirm the testimony you shall give shall be the truth under penalty of perjury? Mr. Dixon?
Yes, ma'am.
All right, Mr. Edwards?
Yes, ma'am.
And Miss Allen?
Yes, ma'am.
Okay, can I lower your hands? I'll go chronologically. So, Mr. Dixon, did you agree that a writ would issue after November 2nd, 11:59 p.m.?
Yes, ma'am.
Did you consent to a monetary judgment through that date in the amount of $3,278.41?
Yes, ma'am.
All right, we'll make that the order in your case and you're free to log off, sir. All right.
All right. Thank you so much, ma'am.
Thank you. All right. All right, Mr. Edwards, did you agree that a writ would issue after November 2nd?
Yes, ma'am.
And did you consent to a monetary judgment through that date in the amount of $2,542.96?
Yes, ma'am.
All right. We'll make that the order in your case. And Mr. Edwards, you're free to log off. All right.
Okay.
All right, Ms. Allen, let's see. Did you consent to a writ to issue after October 31st, 11:59 p.m.?
Yes, ma'am.
And did you agree to a monetary judgment through that date in the amount of $2,526.91?
Yes, ma'am, I do.
Okay. Then we will make that the order of the court. Is Genuine Glover
Thank
present
you.
so I can confirm with him as well?
Yes, he is. We just have a 7-month-old, so he's just with the baby. But
Understood.
here he is.
How
There
you
we go.
doing?
All right. Hi. Do you
Hi.
swear, I'm having you raise your right hand. Gonna get your hands full. Do you swear or affirm the testimony you shall give shall be the truth under penalty of perjury?
Yes.
All right. Did you agree to a writ to issue after October 31st?
Yes, correct.
And did you agree to a monetary judgment through that date in the amount of $2,526.91?
Yes, correct.
All right. That will be the order in your case. You're free to go, and your baby is beautiful. So have a great day.
Thank you. Have a great day, ma'am. Bye.
With Penco Corporation, do you know what case you're here on?
I'm not for sure. Hodges, is this for Christopher Williams?
Probably 7. I think Mike already did it. Yeah, it's 7, Christopher Williams.
Yes, you did that one already.
So we're done?
Yes.
Okay. Thank you so much. Have a good day.
You're welcome.
Oh. Okay.
Person that just logged in on the Samsung, can you unmute and start your video? Person that just logged in on the Samsung, can you please unmute and start your video?
Can you hear me?
Yes, sir, I can hear you.
Please, everyone, remain on mute. We're just waiting on the attorney to come back to go over the terms of your agreement. You can go off camera right now if you would like. If you just joined, please go ahead and start your video so we can know who you are. So everyone else, if you've already spoken to the attorney, you all are fine. I'm just speaking to the people who just joined. Last name Powell and the person on the Samsung. Can you all please start your video? All right, person on the Samsung, are you able to unmute?
Are you referring to me?
No, sir, you're fine.
Okay.
You're fine. So I'm sending you a prompt to unmute the person on the Samsung. Can you hear me?
Yes, ma'am.
All right. May I have your name?
Gimby Frank.
Last name Frank.
Yes.
Okay. All right. You're position 29. Okay. I'm going to go ahead and rename you. Then I'm going to send you into a breakout room 29, okay? Once you get in that room, just wait in there until an attorney comes in to speak with you about your case, okay?
Okay.
Person labeled Derek Howell. Can you please unmute and start your video so we know who you are? All right, so I'm just going to put you back in the waiting room.
Can I put you on hold for 1 second?
All right, number 21.
Oh,
Let's say I have a few announcements.
okay.
21 is a consent. He's going to try and get it paid, but it's a consent writ to issue November 2nd, 11:59 p.m. and a judgment for 4,074.73.
Say that again, the amount? Sorry, 4,000.
40.7473 cents.
40.74.73. Got it. Mhm.
Number 22 is a consent writ to issue November 2nd, 11:59 p.m. and a judgment for 23.62.19.
Okay.
Number 23, same thing. They're going to try and pay it, but it's a consent writ to issue November 2nd, 11:59 p.m. and a judgment for 49.90.75 cents.
Okay.
26. She's going to try and pay it. It's a consent writ to issue November 5th, 11:59 p.m. Judgment for 70.59.51 cents.
Okay.
27 is a consent writ to issue November 2nd, 11:59 p.m. and a judgment for 20.19.95 cents.
Okay.
28 is a consent writ to issue November 2nd, 11:59 p.m. and a judgment for 21.50.49.
All right.
Number 29 is a consent writ to issue November 2nd, 11:59 p.m. and a judgment for 1609.40 cents.
All right.
Number 30.
Oh, 30. We just did 30.
Just did 30?
I got November 2nd, 1609 and 40 cents.
Oh, I meant that to be for number 29.
Oh, is 29 here?
Yes.
Mr. Frank.
Yes, he came late, Judge.
Gimby?
Oh, he came late. Okay, hold on. So for 29, it's 11 to 1609.40. All right, and 30 then?
Same thing. They're gonna try and work it out. It's a consent writ to issue November 2nd, 11:59 p.m. and a judgment for 1871.69.
Okay. All right.
And then I've got, I think, two more people one more person I just couldn't seem to get an answer from. So I'll go talk to them.
Let's see if we can get an answer.
All right, thanks.
All right, I'm gonna have the individuals here in the quorum with me. If you can all unmute and turn on your cameras so I can swear you in and then go over your consent agreements. We have Darden. Figueroa. Can you hear me? Number 19, Figueroa.
Yes, I can hear you.
Can you turn on your camera?
It's not allowing me to. I don't know how I even have my camera get turned off.
Let me see. I'm gonna send you a prompt. See if that works.
Can you resend it? Accidentally.
There we go. There you are. All right, I'm gonna have everyone. Jenkins, I'll have you turn on your camera as well. Everyone can raise your right hands. Do you swear or affirm the testimony you shall give shall be the truth under penalty of perjury? Jenkins?
Yes.
All right. When you've responded, you can lower your hand and put yourself back on mute. All right. Figueroa?
Yes.
No, Figueroa.
Oh.
Number 19, Figueroa, did you hear me?
Yes, I can hear you.
Okay. And do you swear to tell the truth then?
Yes.
All right. Can lower your hand. Darden? And did you swear to tell the truth?
I do.
All right. Thank you. And Outen, position 22, do you swear as well to tell the truth?
Yes.
All right. Thank you. Douglas, do you swear to tell the truth?
Yes, ma'am.
Thank you. You can lower your hand. Isham, do you swear to tell the truth?
Yes, ma'am.
Thank you. Fagan, did I call you? Do you swear to tell the truth?
Yes.
All right. And Mr. Frank, do you swear and tell the truth?
Yes.
All right. And Miss Etheridge, do you swear to tell the truth?
Yes.
All right. Thank you. You can lower your hand. I think I got everyone. Let me see. I'm going to go chronologically. So we'll start with position 21. That's Mr. Darden. Find you. Mr. Darden, did you agree that a writ would issue after November 2nd, 11:59 p.m.?
Yes, ma'am.
All right. And did you consent to a monetary judgment through that date in the amount of $4,074.73?
I can try to do my best, Judge.
Understood. All right. Well, then I'll make that the order of the court and you're free to log off. All right. Best of luck. All right.
Thank you.
Thank you.
Hmm?
All right. Position 22. That's Adrian Outen.
Yes, ma'am.
All right. Did you agree that a writ would issue November 22nd?
No, ma'am.
No, you didn't, because that's
I
not what I
thought he
wrote
said
down.
no. I thought he said.
Yeah, he said November 2nd.
Yes, I did.
You're right. All right. And did you agree to a monetary judgment in the amount of $2,362.19?
Yes, ma'am.
All right, you're free to log off then. Thank you.
Thank you. All right.
All right, Ms. Jenkins in position 23. Ms. Jenkins,
Yes,
can you hear
ma'am.
me? All right, Ms. Jenkins. Did you agree that a writ would issue November 2nd? After November 2nd?
Yes, ma'am.
And did you consent to a monetary judgment through that date in the amount of $4,990.75?
Yes, ma'am, I did.
All right, and I'm going to make that the order in your case, and you're free to log off. All right.
All right, thank you.
Thank you. All right, Miss Douglas, position 26. See, did you consent to a writ to issue after November 5th, 11:59 p.m.?
Okay. Yes.
Okay. And did you agree to a monetary judgment through that date in the amount of $7,059.51?
I didn't agree to pay. I have a program that's gonna pay, but
Okay, so did
so
you
say
agree, I guess, that someone will pay it on your behalf then? Is that kind of what I'm understanding?
they're just on a freeze because of the shutdown. So
Okay.
yes.
But was that the amount that you agreed to, the $7,059.51?
Yes.
Okay. All right. Then we'll make that the order of the court. And a written order will come to you in your email, all right?
Okay, thank you so much for your time.
All right, thank you. All right,
And log off.
Miss. Oh, yes, you can. Thank you.
Thank you.
Miss Asham, can you hear me?
Yes, ma'am. It's Aisha.
Isham, I'll get it right one day. All right, Miss
Hopefully, I
Isham.
don't have to be here again.
Hopefully, yes, true. All right. Did you agree that a writ would issue after November 2nd, 11:59 p.m.?
Yes.
Okay. And did you consent to a monetary judgment through that date in the amount of $2,019.95?
Yes, and that judgment is only made if I don't give my apartment the money that's owed, correct?
Right. If you work something out with your property before that and they accept money from you, then it would cancel out this agreement.
Awesome.
It looks like you're trying
Okay.
to work something out with them. Is that correct?
Yes, because I applied through the home ARP program, so I'm waiting to be contacted.
Right. So if you make any payments to them before the 2nd, then it does cancel out this agreement and you can
Yes,
stay
ma'am.
on the property, work out whatever you do with them.
Awesome.
Okay.
Thank you.
Can you
All
pass
right,
me
Miss.
that too? Like, can you pass me that too? That payment plan program thing?
It's through the DeKalb coordinated entry line. It's a phone number. Just look up DeKalb coordinated entry. It does take like 4 to 6 weeks for you to receive assistance and get contacted. I haven't even been contacted yet, and I called them on September 11th. Excuse me, Judge.
You're fine. That's good.
Sorry, I was trying to, yeah.
I'm sorry,
Well,
Judge.
thank you. Oh, you're fine. You're free to, let's see, Miss Fig, and you're next anyway. Did you agree to a writ to issue November 2nd?
Yes.
Okay. And did you consent to monetary judgment in the amount of $2,150.49.
Yes.
All right, Ms. Fagan, I'll make that the order in your case and you're free to log off, all right? Mr. Frank Ngimbi then. Did you agree that a writ would issue after November 2nd, 11:59 p.m.?
Yes, ma'am.
And did you consent to a monetary judgment through that date in the amount of $16.0940?
How much is that?
I have $1,609.40. Is that what you have?
That's for 2 months?
No, that's a judgment that they could collect against you, that you're agreeing that they can collect against you. Now, if you're trying to work something out with your property, you have to work something out with them before November 2nd. And the amount of money they may want from you to stay on the property is probably going to be different than this amount, because this amount, the $1609.40, is only the judgment or rent through November 2nd.
Okay.
Okay.
Yes.
All right. Then I'll make that the order for you and you're free to log off. All right.
Yes, thank you, ma'am.
Thank you. All right, Miss Etheridge. There you are. Did you agree to a writ to issue after November 2nd?
Yes.
Okay. And did you consent to a monetary judgment in the amount of $18.71.69?
Yes.
All right. I'll make that the order of the court and you're free to log off. All right.
Thank you.
Thank you. Miss Figueroa, did we go over? I thought we went over your. No, we didn't go over your case.
No, we haven't.
Did you speak with the attorney?
No, we were on for a brief second, but I was dealing with my kids, so I think he had went to a different person.
I couldn't hear you, Miss Figueroa.
Oh, okay.
All right.
We'll try.
Yeah.
Why don't you get back into the breakout room, Miss Figueroa?
Okay.
And you can speak with Mr. Hodges. And then what was happening with Miss Hurd?
I just couldn't. She couldn't hear me.
I can't hear him or speak.
So, Miss Hurd, can you hear me now?
Yeah, I can hear you, but when he's talking, I can't hear anything.
Yeah.
Okay. Miss Hart, do you think we should put them in a different, Miss Hurd in a different breakout room? I don't know.
I can do that. I can put them in room 1.
All right, let's try in a different breakout room. Sometimes that works, sometimes it doesn't.
Ms. Hurd, if we can't do that, then please pay attention to the chat.
Okay, I've been chatting. It's in there. I've been chatting with you.
You missed a couple of my messages, but
okay.
let's try again.
Okay.
All right. Just let me know.
Person that just logged on, can you please start your camera?
Ms. Hurd, were you able to speak with Mr. Hodges? Oh, you're on mute.
Yes, ma'am, I did.
You did? Okay. All right. So you're just waiting for him to come back out now?
Yeah.
Okay, great. All right.
All right.
My party, mommy. See my parties.
Looks good.
All right. Number 15.
Ms.
Yes.
Hurd, yes.
She's going to try and get it worked out, but there's a consent writ to issue November 5th, 11:59 p.m. and a judgment for $4,011 and 35 cents.
What was the last part? How many cents?
35.
35. Okay.
19
Mhm.
is a consent writ to issue November 5th, 11:59 p.m. and a judgment for 4365.93.
All right. Ms. Figueroa, I already swore you in. So did you agree that a writ would issue after November 5th?
Yes.
Yeah,
Okay.
lights on.
And did you consent to a monetary judgment through that date in the amount of $4,365.93?
Yes.
Okay. Then I will make that agreement the order of the court. You're free to log off, all right?
Thank you.
Thank you. All right, Ms. Hurd, I'm gonna have you raise your right hand. Do you swear or affirm the testimony you shall give shall be the truth under penalty of perjury?
Actually, true.
Okay. I'll have you lower your hand. Let's see, Ms. Hurd, did you agree that a writ would issue after November 5th?
Correct.
Okay. And did you consent to a monetary judgment through that date in the amount of $4,011.35?
Correct.
Okay. All right. I will make that the order in your case, and you are free to log off.
All right. Thank you, Judge.
You're welcome. You take care. All right.
You too. Thanks.
Okay. Bye. All right, Mr. Hodges. Let's see what defaults we have. I think number 8 is my first one.
Number 8, motion to strike. Request for written stanter and a judgment for $43.51.11.
All right, motion to strike granted. Writ will issue in stanter. I've got a monetary judgment in the amount of $43.51.11.
Great. Thank you, Your Honor. Number 11, weren't they here?
No,
No? Okay.
got them as a no response.
Okay.
Ms. Hart, did you have them here?
No, Judge, they never showed up, but they
Okay.
signed for their notice. Though.
Okay.
All right. Motion to strike, request for written stanter, and then a judgment. My apologies. I've got to do the math quickly. $2,076.61.
Motion to strike is granted. Writ shall issue in stanter. Monetary judgment $2,076.61.
Number 20.
20. Oh, that case was dismissed October 20th.
Okay. Good deal.
Is that it then?
And yeah, that's all the
Just it?
cases.
All right. We
All
did
right.
it. All
Thank
right.
you all very much.
All right. See you next time.